I want to bring in trial and compliance attorney Seth Berenzweig and former federal prosecutor and contributing editor for New York Magazine, Ankush Kardari. Thank you both for being here. First of all, I mean, this number, again, keeps going around in my head. This is an astronomical figure. Now, he takes issue with the amount, calling it possibly an excessive fine. That's a discussion for an appellate court to grapple with. I don't know how he'll fare. But when it comes to seizing these assets, just walk us through, if you can, for a second, Seth. Sure. James, so she would not necessarily be able to seize properties that he is not the sole owner of, right? She'd be in line as a creditor.
She would be in line as a creditor, but keep in mind that all of the defendants in the case, the organization and the entire family, are jointly and severally liable for the debts in the case. So it's his company, it's his kids, it's him. And this filing is basically a warning siren to the Trump family that this is a red alert. This means that when you docket a judgment in the county courthouse in the records of that county within New York, that means that his assets are in peril and there's no way out. By the way, that is a filing not only with respect to real estate, but it creates a judgment lien against all realty and personalty. What does that include? Operating accounts, bank accounts, everything. And she can execute on that next week. And if she chokes that money dry, that means that it'll probably violate a whole bunch of loan covenants. It's going to be a hot mess, and it's just days away.
I mean, you could garnish wages ultimately, right? At one point, and just I'm thinking about if he were to secure the White House again, the idea that you could possibly garnish one's presidential salary, obviously far short of this notion here, but there is that process. Let me ask you, Ankush, because, you know, bankruptcy might be in people's minds. They might think to themselves, okay, well, hold on. If you can't pay the judgment by Monday, there's a process for her to begin seizing assets. It's not going to be like, you got to put it on the market right now, and I got to get money next week. Could bankruptcy help him avoid any of this? It's not able to be so, right?
No. So he will not be able to discharge, is the word, the legal term of art, this debt in a bankruptcy proceeding. It's a court judgment and also happens to concern intentional misconduct on the part of Mr. Trump.
So neither of those are the categories you can actually have a bankruptcy apply.
Right. And so the best that he could accomplish is to sort of drag the process out by filing for bankruptcy, but it would not prevent the state from getting their money. The other problem is I'm not sure he's insolvent. That's sort of unclear to me, too. So I don't think he can just, you know, pop on over and file for bankruptcy. He claims to have all this money, all these assets. He can sell some of them. He can mortgage them. He can try to do something with the shares that that are going to come to him through the True Social SPAC merger. He has options here. I think there was a little bit of posturing going on this week, with his claim that it's a practical impossibility to get the bond. He has options. He just doesn't want to pursue them.
And by the way, she would know at this point, the Attorney General in New York, what properties he owns, right? This is idea. I mean, the judgment comes down from this judge, but there is a kind of forensic accounting that's already taken place, right?
That's right. It's all a matter of public record. And one of the other things that's unique about this case, as far as the operating company goes, is that the judge in the New York case has applied a special receiver that has control over all of the operations and the assets of the corporation. So, and in fact, that was an order that was brought in within the last 24 hours, where the judge told the corporate receiver that she has all the power she needs to monitor the cash, monitor the accounts, and he invited her to reapply back if she feels that she needs more powers. What that means is that when there is a garnishment of a bank account, for example, what typically happens in a situation like this is that the CEO says, that's fine, we'll just sweep the account and then we'll send it over to Bank of America. He can't do that. He can't move the money. He's stuck. He can't file for bankruptcy. He's really in a tight place right now.
Well, I mean, you just look at this, and the response that he has had consistently, Ankush, has been, this is all political, right? This is somebody who campaigned on trying to bring me down. I was her target in the campaign. Politically, obviously, she would not dispute that she has campaigned on prosecuting Donald Trump. In an appellate process, though, as he starts to work on this appeal about this judgment, is that ever going to factor in?
You know, I don't look, the argument that it's like political, I don't expect to have much traction within the courts in New York. I do think that there is that argument underlies a problem with the judgment that I think is going to potentially be vulnerable on appeal, which is that the numbers are very large. It is very large, particularly for a fact pattern like this one. In New York courts under this type of law. So I don't expect the courts to say, oh, this was political, we're going to throw it out. I do expect them to be a little careful with these facts and looking closely at the judgment and the underlying law.
Well, they'll have to look at the proportionality of this, right?
Exactly.
And who is before this actual court.
Yep.
Seth, Ankush, please take a look around in just a moment. Back with me now, Seth Berenzweig and Ankush Kardori. I'm so glad you guys are back because this idea of a summer trial date. Now, when she first came on the scene to announce this indictment, she first said, I want to have this trial in 6 months. Now, many people began to snicker and laugh, thinking there's no way that a co-defendant case of this magnitude would go that quickly, let alone one that involves the former president of the United States. Ankush, is it realistic to think that this could happen this summer? By the way, it'll be April, like in 2 weeks.
Yeah, I don't think it's realistic. I don't think that there was a very good chance this case was even going to go to trial this year, even after it was filed. And this is a 19-defendant case, complex issues, novel issues in some respects, involving a former president. It was always going to be a very ambitious notion to have this case tried this year. Now, the other problem she now has is this disqualification issue, which was just resolved against her, is up on appeal, right? It's going to be appealed. And I do not see why the judge would want to schedule a trial that may be invalidated if he's overruled on the disqualification issue, right? So I don't see why a judge would even contemplate having a trial unless and until that appeal is resolved. So he knows that the prosecutor on the case is actually the prosecutor on the case.
But, you know, there is a world where you could say, I'm going to keep planning, and I've made my finding. I believe that she should not be disqualified, so I'm going to proceed as appropriate. She does have a history of having these large co-defendant cases, whether it's a teacher's cheating scandal or the YSL case down in Georgia, which, by the way, I think is still ongoing when you think about these cases. But these last 2 months, you have to wonder what impact that's had on preparation, Seth, because, of course, her lead prosecutor is now not there. That means somebody else has to step into that role and get up to speed.
Well, I agree. It will have an impact, and certainly they've had a little bit of disruption in the office lately. However, I'm a little bit more optimistic from a speed point of view. Under the local rules, now that Judge McAfee has given sort of this permission slip for Mr. Trump and the defendants to apply for permission to ask the Court of Appeals to accept the case, under those rules, that documentation is due within 10 days of when he entered that order, which is basically in about a week or so. Then the Court of Appeals has up to 45 days to make its decision. Now, of course, if they go in and they end up being a traffic cop and say, stop the presses, we need to take a look at this, then I completely agree. There's no question at all that this case is getting tried this year. If they reject the appeal, although it's tough, I still think that there's a slim chance that it could get tried in the early fall. That is something that might be a tough squeeze, but everything's going to move pretty quickly within the next few weeks, and we'll know for sure whether or not the Court of Appeals accepts this and whether they're going to put a stay on the case.
You know what's looming pretty largely over this entire thing? I mean, she is an elected official, right? She's got a primary in May. She has a challenger. There's obviously the general election in November. And so in a very weird way, Ankush, the two of them, talking about Trump at the very least and Fani Willis, they've got something in common, not just this indictment, but the fact that they are they're hoping to be and remain in office again. Does that influence, you think, the way and the timing of how this case is pursued? Because if she doesn't win re-election for whatever reason, then that could be a new team that comes in.
No, from her perspective, that could be something she's concerned about. Again, I just remain a bit skeptical that would be the sort of paramount interest on her mind. I mean, I think that she is clearly very attentive to, you know, the coverage around her and the perspectives of the media, people in her community. That's been very important to her over the last couple of months, understandably. And I imagine part of her decision today, or the reporting that CNN has today, is about her trying to turn the page on all of this, right? And try to move forward, even if she doesn't get her trial date, just to say, look, that happened. Now let's move into a new phase of this case where we can get back to the facts and the law and the evidence.
You know, interestingly enough, the judge in his ruling, keeping her on the case, talked about how he did not believe that they were involved in this relationship or using this indictment as a pretextual reason to continue it, because he said because she has proceeded with all due speed in this case, not wanting to sever, wanting to have a quick trial date. And so it's a bit of a catch-22 if she now were to slow this all down. Seth, Ankush, thank you both so much.